You're listening to People, Places, Planet, the official podcast of the Environmental Law Institute, a nonpartisan, nonprofit research and education institute making law work for people, places, and the planet. If you enjoy the podcast and want to support our work, consider donating at eli.org/donate.
Welcome back to another episode of People, Places, Planet. I'm your host, Sebastian Duque Rios, and today we are joined by three legal scholars who are keen to share some of their insights and to highlight the relevance of Indigenous theories in international and domestic environmental law. Today, I'm joined by Margaret Palaghicon Von Rotz, a fellow here at ELI, Jonathan Liljeblad, a law professor at Australian National University, and Kristen Carpenter, the Council Tree Professor of Law and Director of the American Indian Law Program at the University of Colorado Law School. Would each of you like to take a moment to tell us a little more about your background?
Yes, I'm a law professor at the University of Colorado, as well as the co-director of the Implementation Project, which is a joint initiative between our law school and the Native American Rights Fund, which is the leading Indigenous advocacy organization in the United States. That project aims to implement the UN Declaration on the Rights of Indigenous Peoples in the United States, working on education and advocacy to make that happen. And in that project, I draw a lot from my previous experience serving as the chair and member of the United Nations Expert Mechanism on the Rights of Indigenous Peoples, which is a body that similarly tries to advance the aims of the Declaration, in that case, around the world.
Yes. So the English or Swedish name is Jonathan Liljeblad, Associate Professor at Australian National University. My original name was actually Nanda Zawin, and I'm a member of the Pa'o Indigenous peoples of what is now Burma or Myanmar, from an area called the Shan Hills. And my current research agenda is predominantly about Indigenous legal orders at the international level and the concurrence of Indigenous legal orders within the international legal system.
I'm Margaret Palaghicon Von Rotz. I am a fellow here at ELI. I'm the Public Interest Environmental Law Fellow. Prior to my fellowship, what I've been working on in my research had been on fourth world approaches to international law, which is what inspired today's conversation. During my JD, I wrote my student note on climate change-induced displacement of Indigenous peoples. And then during my LLM program, I wrote my dissertation on conservation-related or biodiversity-related displacement. And since then, I've continued to write about protected areas, World Heritage Management in the context of Indigenous peoples and looking at that in the context of international Indigenous legal theories. I'm also a member of the Tuwali Ifugao Indigenous peoples of the Northern Philippines in the Ifugao province.
Thank you to all three of you for joining me today. Really excited to have this conversation. Jonathan, you're editing a forthcoming book in which Margaret is a chapter author, Indigenous Theories of International Law, Living Internations, Legal Orders. Can the two of you tell us a little more about the impetus for this project?
So let me just preface my comments real quickly and just acknowledge the fact that, I'm coming to you from Australian National University, which is on the lands of the Ngunnawal and Ngambri peoples. And the reason I'm acknowledging country, is to use the Australian term, is that it gets to the premise of the project that we're working on. And specifically, what we're trying to demonstrate is that there are Indigenous legal orders that exist outside of and concurrent to the prevailing state-based international legal system. And we're trying to stress that these Indigenous legal orders, that they are very much alive and that they're ongoing right now. This is really coming out of a convergence of two different strands of scholarly discourse. So there's one strand, which is the historical component, which is arguing that the existing international legal system that we live with right now is predominantly state-based. We see that we have international institutions which involve primarily states as actors. So this is the United Nations, the World Trade Organizations, where it's the states that have membership. The venues of international justice primarily center on state actors as having legal rights and duties. So this is entities like the International Court of Justice. We see things that are deemed to be authoritative sources of international law. So treaties, declarations, with states that are the primary parties to these kinds of instruments, and it's the states that give consent to be bound by these kinds of instruments. And what we're responding to out of this is the second strain of literature, which is that the Indigenous legal orders have an alternative approach, a different conception about what are authoritative sources of rules, and also different ways of doing law in terms of how we apply these kinds of rules. So I'll leave it at that.
Fantastic. To give our listeners some context, could you talk a little bit about the origins of international law and how it has historically excluded Indigenous peoples?
So with respect to the question about the origins of international law, our project is not historical analysis. We're not going into a long history or deep history of international law. But what we are talking about is sort of the foundations for what we see now to be a state-based international legal order. Quite a bit of literature has pointed back to the Peace of Westphalia of 1648 as sort of giving the dawn of the idea of the state and the primacy of the state. What we look to is the literature that identifies the concurrence of the international legal order as part of an era of Western imperial expansion going from the 17th, 18th, 19th, and into the 20th centuries, and that the international legal order was a way of legitimizing and installing a particular way of doing business, law, cultural expansion. As a result of that, right now, the international legal system is carrying a historical legacy effectively about imperialism. And even though we are now living in a post-colonial era, we see the manifestations of that now.
Thank you for offering some of that context, Jonathan. Margaret, Kristen, did either of you want to add anything there?
Yeah, I think it's covered really well. What I would add would be the environmental context when it comes to the origins of international law. So much of what international law has done since the Treaty of Westphalia has been about legitimizing territorial dispossession of Indigenous peoples. And so the environmental aspect there that I do want to highlight when it comes to traditional forms of international and environmental law are what we call fortress conservation. And when we use the term fortress conservation, we're talking about how states are kind of the central players in international law when it comes to all these different international legal instruments. It also means that when we talk about different areas of land or different areas that we want to conserve or protect for environmental reasons, the state becomes the primary caretaker as opposed to local communities or Indigenous peoples.
So when we look back at the origins of international law as tracing to the emergence of nation states and the Treaty of Westphalia, I think that is one perspective on the origins of international law, which is distinctly European in nature, and it is the mainstream one. As we're trying to indigenize international law, it's also worth looking back at some of the indigenous origins of diplomacies among peoples, which we can actually trace back even to earlier dates than 1648. One example from my region, and I'm coming from North America, is the well-known Haudenosaunee Confederacy, where 5 indigenous nations gathered as far back as perhaps the 1100s or at least the 1300s to develop union among them, in which each of the 5 nations would have certain responsibilities to the whole, and the individuals within would also have a system of duties and relationships to each other. This is often cited as an early example of Indigenous peoples' own international law, even if that wasn't the terminology used at the time. These weren't nation states per se, but Indigenous peoples with their own laws, customs, and traditions.
Thank you, Kristen. We've been talking about indigenizing international law. Margaret, could you maybe just break down what exactly does that mean? What does an indigenous theory of international law mean, and what does it look like?
We've been talking about it from the standpoint of what nation states are and what that means from like a strictly European sense. There have been responses to that type of approach since then. There's what's known as the third world approach to international law, which is a whole body of scholarly work that looks at international law from the lens of nation states in the global south. And what that does is instead of looking at nation states as kind of all these equal players on one equal playing field, it looks at states as actors on an unequal playing field, particularly because states that were former colonizers do have certain economic advantages or can control the international economic order through different financial or monetary institutions. Some scholars have put forth the idea of a fourth world approach to international law. So instead of looking at it as just here are these nation states coming in with different levels of power in the international legal system, what if instead we separated this idea of nation and state and recognized that there are indigenous nations embedded within kind of those first, second, and third worlds? And I do want to note that there are scholars who have even pushed back on this idea of identifying it as fourth world. Fourth world has a term that's been around since, I want to say, the 70s. It was coined by Canadian First Nations leaders. But even that idea has been kind of pushed forth into the idea of original nations approaches to international law. But the point being is that we're separating this idea of nation and state, that there are nations that exist within states, and that they could also be a building block or an actor within international law. By thinking of it that way, we can also understand that it's not just that typical story of the global North states are bad actors and the global South states are the good actors. It is far more complicated than that. And I also say this as an Indigenous person from a global South state like the Philippines, where I don't want this homogenous idea of the Philippines as like this wholly good actor, when in fact the Philippines as a nation state doesn't necessarily treat its own Indigenous peoples or Indigenous nations on the same level as other peoples within the state. So being able to separate this idea of nation and state allows us to better see what the actual dynamics are within these so-called nation states. And it also gives us opportunities where Indigenous nations and third world states ally together, cooperate, assuming those Indigenous nations have recognized status, and what that could mean for international environmental law. Those are just thoughts that I've had throughout my own research. I would also love any thoughts or comments from Jonathan or Kristen about it too.
Yeah, I'll just add on to Margaret because it ties in directly to our project, and then I'll defer to Kristen with her perspective. So I just wanted to add on this entire discussion about FWAIL, or fourth world approaches to international law. It's building upon previous work that already exists, right? There's scholarship done by various Indigenous authors within Australia. The figures that I always refer to are Christine Black and Irene Watson, who've consistently and very vociferously have asserted the existence of Indigenous legal orders as still ongoing, and that Indigenous peoples are exercising agency and arguing self-determination. There's also another line of literature that's been talking about global Indigenous movements and the work to try and create solidarity between Indigenous nations or Indigenous peoples in different parts of the planet. And so this is where we see the early works of Jeff Corntassel, Ronald Neetzen, James Anaya, and that they've talked about the growth of these movements and how they've tried to mobilize Indigenous peoples from different parts of the world together. And again, just coming from Australia, I always take a note to the works of Brendan Hokowitu or Eileen Morton Robinson and pay respects to the literature that they've published, which has highlighted Indigenous theory as involving components that we can perceive for heuristic purposes as being ontology, epistemology, methodology, axiology. So ontology is what is it that Indigenous perspectives are studying? How would they identify certain phenomenon or certain issues in a way that's distinctive from, say, larger discourses? Epistemology is like, what's an Indigenous way of reasoning or an Indigenous way of understanding a particular kind of phenomenon? What's an Indigenous methodology in terms of doing activities or what's considered a way of practice? And then axiology, which is sort of the normative parameters of what motivates our actions as Indigenous peoples. So these three different bodies come together, and through our project, we're trying to identify them. The other thing I just want to note here is that in our current conversation today, we're using the term Indigenous theory, singular, and I just want to issue a viso on that, in the sense that Indigenous peoples are not monolithic. There's an incredible diversity around the world in terms of communities that identify themselves as Indigenous, and that this means that there's a richness to the perspectives, there's a richness to the ontologies, epistemologies, methodologies, axiologies, and that this is one of the components of our project, is to try to open up space for a new subfield or a new field to allow these different perspectives to assert themselves and to express their own particular understandings and conceptions of what would be an internations legal order that's concurrent to a state-based international legal system. So I'll stop on that one.
We can chime in with some specificities with respect to Indigenous peoples and their work to indigenize international law. We at the Implementation Project, and also in my scholarship with Angela Riley, have had a chance to work with some of the traditional people and some of the indigenous nations here in the United States who have taken instruments like the UN Declaration on the Rights of Indigenous Peoples and quite literally translated it, first of all, into their own indigenous languages. And so, for example, the Muskogee Creek Nation, now located in Oklahoma, translated or interpreted the Declaration into the Muskogee Creek language through a series of in-depth conversations with first language speakers in communication with tribal lawyers and judges and others to develop what they then called the MDRIP, the Muskogee Declaration on the Rights of Indigenous Peoples, and then adopted it into tribal law so that it's now applicable law within the entire boundary of the Muskogee Creek Nation. And they did so with some intentionality because that tribe in particular has been involved in international law going all the way back to Philip Deere in the 1970s, who was a traditional leader going to Geneva to engage in discussions about human rights. And they were very gratified to see the adoption of the Declaration, but really wanted to bring it full circle and bring it home in a literal sense to interpret some of the concepts through their own language and culture. One article that they've talked quite a bit about is Article 31 of the Declaration with respect to traditional knowledge and the importance of conceptualizing in distinctly Muskogee terms what it means to take care of knowledge that belongs to a particular community and what duties of care they feel are important to abide by in the present and for future generations. We've also worked quite a bit with the Navajo Nation Human Rights Commission, which uses the Navajo language and the Navajo fundamental law in advocacy alongside not only the Declaration, but the International Covenant on Civil and Political Rights, and quite a few treaties to articulate what concepts like the right to life or right to religion, right to water mean in distinctly Navajo terms. And those terms then inform the advocacy and diplomacy that they engage in internationally. With my co-author looking at some of those examples, and we have quite a few, we called this more theoretically a jurisgenerative moment in Indigenous peoples in international law, borrowing the famous phrase from Robert Cover, jurisgenerative being law creating. And it sounded at the time like kind of a fancy multisyllabic phrase, but then we found out that traditional Indigenous leaders at ceremonies and communities really liked this idea quite a bit, that they would be able to participate in a law-creating moment, taking international law, taking, of course, national laws, which they have to deal with, and bringing their own laws into the conversation to produce something new, something both traditional and current at the same time. One of those leaders, actually from the Yuchi people, Greg Bigler, wrote his own article about traditional jurisprudence, and he talked about the jurisgenerative tail after a rabbit's tail that does some of this work in terms of Yuchi language and culture. And in terms of indigenizing international law, his article is one that I would certainly recommend to scholars and practitioners. It's really nicely situated in theory, but also in terms of very practical work. He's both a ceremonial person and a judge, and I think it provides a wonderful set of examples.
Thank you, Kristen. And I think you started to touch a little bit on some examples of what would it look like. Jonathan, Margaret, do either of you have some that you'd want to share?
I can go. So because we've been talking about like this book that Jonathan is putting out, of which I get to be a chapter co-author, I can touch on what my chapter is about, which is about World Heritage Convention, management of World Heritage sites that fall on Indigenous lands. And so what we talk about in ours is pretty personal for me because I talk about a site that is in Ifugao, which is where my family is from. I like to use it as a case study because it is an example of a World Heritage site that didn't start as an Indigenous-led project. So the idea of a World Heritage Site is to create this protected area within a state or a nation state for the sake of cultural and natural heritage for all of humankind. And so it's an international agreement that places obligations on states to protect those areas. This very often will happen without Indigenous consent, will often lead to displacement or eviction of Indigenous peoples for the sake of protection under the World Heritage Convention. There have been a lot of improvements since then. I touch on it a little bit in the chapter, but I use Ifugao as a case study for that because our World Heritage Site is of the rice terraces, which is also just like very central to our culture. The site was started, I want to say, in like the early 1990s, and this was prior to the Indigenous Peoples' Rights Act was passed in the Philippines. With the passing of that act, things couldn't be done on Indigenous lands without free, prior, and informed consent, which is now the standard under the UN Declaration of Rights of Indigenous Peoples. So this was prior to all of that. So it was done without Ifugao consent or without community consent. And since then, the management has shifted completely under local Ifugao Indigenous control, which has been really interesting. They've really adopted what I call kind of this legal pluralist approach that I talk about in the chapter. And so what led to that was actually the site was listed in the 90s as under protection for World Heritage. But then 10 years later, I want to say it became an endangered site and threatened to be delisted because it wasn't being sufficiently protected. So this led to a lot of investigations and reports of what is happening. Why are the rice terraces not being managed or protected in the way that they should? And of course, tale as old as time is because the indigenous local peoples who were actually farming the lands and using the lands weren't being properly consulted. A lot of it was actually based on kind of these different terms of what should be protected. And so a lot of the original listing for the World Heritage Site was focused on the aesthetic beauty of the rice terraces. And don't get me wrong, they are quite beautiful. But in our native language in that region, there is no word for beautiful. We only have the word for good. I even asked my mom about this as I was writing. I was like, how would you say if the rice terraces are beautiful? She's like, you would never call them beautiful. You call them, a work of craftsmanship. You talk about them in the sense of like, they have this very great use and a great function. But when you focus on the aesthetic beauty, then you're missing these other less beautiful parts of the ecosystem and yet are central to the ecosystem's functioning, such as these forests around the terraces that are very vital for the health of the ecosystem, but aren't aesthetically beautiful and were thus being cut down for the purpose of better views to these rice terraces. And so because of these different interventions that have happened since the early 2000s and as recently as last year, different local groups finally became involved, including the farmers that actually own the lands, and they were able to get off of the list of World Heritage Sites in danger. And now it's fully okay. And so much of that is because of the local involvement. Had you asked any local Ifugao farmers at the time if they knew what the World Heritage Site was, they didn't. And it very much was seen as like just another Western imposition of which my people are very used to, but eventually they were able to take ownership over it, being able to apply different aspects of the Indigenous Peoples' Rights Act to do so. And in many ways, like, yes, the national government is still involved, but here we have an example of Indigenous involvement. And so that's just one example of how an Indigenous approach to international law can be taken in this very local context.
So I'll give two examples, one sort of a positive story and another one sort of a pessimistic story. So I'll start with the pessimistic one first. And this is coming out of some publications I've had previously in my career. And in Southeast Asia, we have communities of peoples that straddle the existing borders. So, it's a case of where you hear this phrase, the border crossed us, we didn't cross the border. And you have the Moken, the Bajau, the Orang Laut communities. So the Moken, they straddle the borders of Myanmar and what's now Malaysia. The Ajau, if I remember correctly, they straddle the borders are between Malaysia and Indonesia and the Philippines. And then you have the Orang Laut, which straddle the borders of Malaysia and Indonesia. And these communities, up until the latter part of the 20th century, maintained their connections across the borders. And so they had these familial connections, they had these group connections that crossed these borders, and they were able to maintain a certain level of continuity in terms of their cultures, languages, economies, and to some degree, law and politics. However, as the borders have hardened, we've started to see an erosion of these because families are no longer able to traverse the borders as easily. And in the case of Myanmar and Malaysia, it's become a very hard border. And so now we have a situation where families are actually being divided, and you're starting to see the disintegration of identities and peoples. A more positive example is what's playing out in what we now call Taiwan and its connections to the Pacific archipelago, where we're starting to see these indigenous-led movements to try and revive these connections. And what's interesting to me out of this is that it's not simply about trying to go back to the past. Instead, a lot of the framing is about trying to understand what happened, number one, and then number two, trying to synthesize some form of connections now that can exist concurrent to the current nation-state boundaries. And so we're seeing a growth of these communications, interactions that provide a certain level of legal, economic, social, cultural connections that span political boundaries. So one of the examples that came out of this and struck me when I actually witnessed it was that you have these fora in the Pacific area that come together, and they go through the normal diplomatic formalities that you would conceive of in the existing international law that's predominantly Western. But then there's also this entire sequence or this entire arena that plays out where they exercise indigenous diplomacies, a very different way of introducing themselves and interacting with each other. And for a lot of Western diplomats, they see it as storytelling. But what someone explained to me was that, well, this isn't just storytelling. These are different indigenous communities are very cognizant of the fact that they have different epistemologies and different ways of dealing with issues. And in order to clarify these differences and to be very transparent, they're trying to explain and introduce themselves through these stories to illustrate their epistemologies, to illustrate the way that they understand certain problems, and that this is actually a part of their way of doing diplomacy. It's not something that is typically seen in a lot of Western venues. With the Western approach, it's very much reflective of international legal customs, and it's also very much emblematic or reflected in things like the Vienna Convention on Law and the treaties and the various international instruments about what constitutes an acceptable way of doing diplomacy. So it's very interesting to sort of see these kinds of developments playing out as we speak.
Thank you all for providing some examples. Kristen, did you have something that you want to add?
Well, coming from work in the United States with Indigenous peoples, I think of two categories of engagement with international law. And certain matters are international by nature. They include claims and resources that cross boundaries. And these involve immigration, repatriation, intellectual property, a number of concerns that Indigenous peoples have. Of course, across borders because their peoples may straddle borders, but also because important resources to them have become very far away at this point. The other category of instances where Indigenous peoples engage in international law, in our country at least, is when they're seeking to take international principles and norms as inspiration for reforming problematic aspects of federal Indian law. And many of us think of federal Indian law as the law of the settler colonial state meant to displace Indigenous people's own laws, customs, and traditions and replace it with federal control and a set of legal doctrines that enables dispossession and various other activities that are harmful. In terms of examples, when I was serving on the UN expert mechanism on the rights of Indigenous peoples, I had the opportunity to work on a country request from the Yaqui people, a cross-border people from the US and Mexico, seeking repatriation of a sacred living object from Sweden. It had been removed almost 100 years earlier through a set of pretty murky circumstances in the provenance. And every time the Yaqui people asked the Swedish Museum for repatriation, the Swedish Museum said no, because as a matter of Swedish law, they didn't believe it had been acquired illicitly. And as a matter of international law, covenant like the UNESCO Convention on Illicit Trafficking provides for repatriation, envisions only state-to-state claims. And so the request allowed the Yaqui people to make their own claim for repatriation to them without a nation-state speaking for them. One of the turning points there was not only use of the UN Declaration, but more specifically within the UN Declaration, there are several provisions which uplift Indigenous people's own laws, customs, and traditions. And the Yaqui people, in response to the Swedish Museum saying, as a matter of Swedish law, this item was not acquired illicitly, the Yaqui people were able to say, as a matter of Yaqui law, this item is a consecrated living being. It belongs to and is cared for a particular religious society, the Colencias, and it can't be held by people who aren't within the society. It can't be removed from the territory. And so they were able to bring their own law into dialogue with the Swedish law, using the declaration and using the expert mechanism as a vehicle to come to an understanding and ultimately to repatriation. One other example that many of you probably know about is the World Intellectual Property Organization's recent adoption of the Treaty on Genetic Resources and Associated Traditional Knowledge. And this is a treaty that was in the works for 24 years. And one of the important components of those negotiations was that there was an Indigenous caucus that was able to participate in discussions, negotiations, and ultimately drafting conversations alongside and with the nation states. They still faced many challenges over the years, and especially many states' opposition to adopting a treaty meant to protect Indigenous peoples against biopiracy. Some of the turning points that I saw there when the treaty finally got through in 2024 were that the Indigenous caucus started to use their national affiliations and their solidarity to break through some of the powerful state opposition. So my own state, the United States, for a long time was opposed to this treaty, but Indigenous peoples in my region were able to talk to the Australian First Nations ambassador, who was a more sympathetic audience than our own country, our own leadership, and also to surface some of the commonalities around appropriation of traditional plant knowledge, the need to protect it, and various mechanisms for doing so.
Thank you all for your thoughtful responses. These examples will really help our listeners understand what we mean when we're talking about this idea of Indigenous diplomacy. To move into the policymaking space, how could policy on an international or domestic level be reformed to make more room for these kinds of relations?
A lot of what we're talking about today is that these are living legal orders that Indigenous peoples, they exist now, they're living entities, and they are engaging in ways that are very much parallel to a state-based international legal order, and particularly with respect to international environmental law, because so much of Indigenous existence is relational. It's tied to particular environmental contexts, that if we're really interested in promoting sustainable and effective international environmental law, we want to be cognizant of and try to work with these Indigenous legal orders that currently exist and try to integrate them as much as possible. So it's not about conflict, but instead about ways of having mutually beneficial and mutually complementary results.
So, Kristen, given your extensive experience in domestic Indigenous issues here in the US, could you share more on why bringing an Indigenous approach to international law would be important in our domestic context?
Yes. So one of the most inspirational aspects of Indigenous peoples' engagement with international law is the way that it empowers them to come back with fresh perspectives on reforming some of the most problematic aspects of federal Indian law. So one of the most fundamental concepts of federal Indian law is that the United States Congress has plenary authority in Indian affairs. This is interpreted in various ways, but as a practical matter, it often means that the United States has unlimited legislative power, even to break treaties or to engage in human rights violations that devastate Indigenous peoples. The UN Declaration on the Rights of Indigenous Peoples does not take this approach. It recognizes the rights of Indigenous peoples not only to self-determination, but to survive as collective entities in Articles 3 and Article 7. It also envisions a framework that's already been mentioned, of free, prior, and informed consent that would militate against the idea of absolute unilateral power by a federal government over Indigenous peoples living within it. I think that both in substance and in process, these aspects of the Declaration have tremendous ability to reform the ways that tribes currently deal with the United States. To mention two other examples, one of the very painful and recurring aspects of federal Indian law in the United States is that the U.S. Supreme Court seems to use it as justification or excuse for denying Indigenous peoples what are otherwise fundamental rights under the U.S. Constitution, such as the right of religious freedom under the First Amendment. And so in case after case after case, the U.S. Supreme Court holds that the federal government has the right to destroy Indian sacred sites, even if it would destroy their religion. obviously making practice impossible. Here is an area where we need reform in the United States. It is not acceptable to destroy American Indian religions under any legal standard, any policy, any national framework, but we have not been able to get out from under the burden of this set of holdings. The UN Declaration has articles providing that Indigenous peoples have rights to access their traditional sites. They have rights to their traditional spiritual properties, to their religion. And this is an area where we could really use reform. Finally, I'll add on a positive example of the involvement of Indigenous peoples in international law. In 2018, for the first time, a federal district court applied and cited the UN Declaration on the Rights of Indigenous Peoples in a case where Jemez Pueblo had sought to recover access to sacred lands in the Valles Caldera area of New Mexico. And although it was just a footnote and just dicta in the case, it helped put in motion what ended up being a land claim settlement such that the Jemez Pueblo people can access their sacred site. And it's pretty transformative because one of those other very problematic rules in the United States is that Aboriginal title, that is land held under Indigenous peoples' own land tenure systems, is not cognizable as a matter of property. And so it has virtually no protections. And the aspects of the declaration that were cited in this federal district court opinion, ultimately leading to a settlement, noted that the United States is an outlier with respect to that standard. And so there, although it took multiple steps and it took another 6 years after the federal district court opinion, there was actually the successful recovery of sacred land in that case.
I want to take a moment for us to focus in on how indigenizing international law can influence other high importance issues in the environmental law field, particularly related to jurisdictional questions or the co-management of natural resources between nations.
In the United States, many of us are focused on the land back movement, and land back has to do with recovering actual title to land, as well as the ability to care for land, even if tribes are not able to own it anymore. It's off-reservation land. And one of the reasons that tribes are very eager to care for the land is so that they can provide environmental stewardship over it. Many tribal traditions have obligations of environmental stewardship where the people must take care of the landscape to fulfill obligations between human beings and the spirit world. I think that, again, international engagement has really helped to inspire Indigenous peoples to be very progressive in these areas. The Yurok Tribe in California, in particular, has enacted law with respect to environmental protection on their reservations. And I would really encourage people to look at those laws. They have a very powerful constitution that articulates their obligations to the environment. And while they work as forcefully as they possibly can through the environmental statutes, the Clean Air Act, the Clean Water Act, and so on, they have also been very active in the land back movement, recently acquiring land along the Klamath River and bringing down some of the dams that is effectively restoring the environment. So those are some examples, I think, where international engagement has moved the needle in terms of environmental relationships between tribes and the world around them.
Thank you, Kristen. Jonathan or Margaret, do either of you want to add anything?
Moving forward, particularly in the climate litigation space, as someone who does a lot of climate work here at ELI, there are examples of Indigenous peoples pushing forward those claims a bit more. So you look at like the Torres Strait Islander case. A lot of that was based on the treaty between Aboriginal peoples and the Australian government. And so those types of claims could be really interesting to see, particularly in the climate space. It even goes as far back as the Inuit petition to the International Court of American Human Rights, where, again, Indigenous peoples were making claims about greenhouse gas emissions of the United States at the time. Those aren't necessarily successful cases, unfortunately, but it does provide a different legal claim that could be made for litigants in the future for climate cases, because a lot of the impacts that we're seeing with climate change in particular, Indigenous peoples are on the front lines and they have more unique damages that they can seek relief for. I think there's a lot of potential growth in that space that we should be on the watch for, at least from like the environmental perspective.
So I'll give an example of transnational mobilization. And in particular, there's something called the Asia Indigenous Peoples Pact, which graciously they've engaged me on a couple of their projects. And they've tried to mobilize Indigenous rights movements across more than 30 countries. A lot of this is to try and deal with what they see as being a recurring phenomenon of regimes across the region utilizing international law for instrumental purposes to consolidate power. And in the case of environmental law, there's this phenomenon that you sometimes have heard as greenwashing. So one permutation of this within Asia is that you have authoritarian regimes that cite their obligations to international environmental law as justification for dispossession of land. So they say that in order to go ahead and satisfy their obligations to the World Heritage System, in order to meet their obligations to the United Nations Framework Convention on Climate Change and its corollary protocols, that the state has to go ahead and take control over carbon sinks, over sea and land territories. And as a result of this means taking control away from the indigenous communities in these areas. And the work of the AIPP, or Asia Indigenous Peoples Pact, in part has been to have knowledge exchange between these different indigenous movements. And then the next step is to then figure out how do they work in response to maintain control over their own territories. This, in some ways, means trying to figure out what are ways of engaging with the existing international environmental legal system, but also it means ways of articulating and expressing their visions of international environmental law in a way that protects their cultures, their economies, and their self-governance.
Thank you. To start wrapping up the episode with some key takeaways, could you all highlight why environmental lawyers should care about an Indigenous approach to international law? How could it affect their work?
In terms of the general environmental issues that we work on, so much of that is happening on Indigenous lands, right? The energy transition, I think, is going to be a big one in terms of where are we getting critical minerals from? At least in the Philippines, a lot of that is happening on Indigenous lands. Not only that, but like the proliferation of data centers, that's going to affect Indigenous land, but also Indigenous water sources. I like to use this example from the Everglades in Florida about the immigrant detention center that's been happening there and how that is technically an environmental case, right? Like it was a NEPA or like an environmental review type of case of trying to stop the detention center from being operated or being built. But the group bringing forward the claim is the Miccosukee tribe in Florida. And I think that's a great example of how an environmental lawyer may not necessarily think, if they're not already working with Indigenous tribes, they may not necessarily think of it as an Indigenous issue. And yet it is, because it is affecting the Miccosukee's ancestral territory and whatever else that might mean for them in that specific place. But I think that's a perfect example of we're using environmental laws for a myriad number of issues. And I think in the same way, environmental lawyers can be using Indigenous treaties, agreements, theories, laws, just so many different approaches that you can use. I think it's about creating solidarity between environmental and Indigenous movements. And that is the way that we push forward Indigenous environmental justice.
Yeah, I think that's a really great example. The work that's being done now regarding alligator Alcatraz is actually also a continuation of work that was done by the Miccosukee tribe all the way back in the 60s, when this area was actually originally scheduled to become a jet port that was going to be 5 times the size of JFK. And it was destined to become Miami's premier international airport. And it was largely due to opposition from the Miccosukee tribe as well as from other local stakeholders that the plan was stopped. And it was also this movement that was the catalyst for the creation of Big Cypress National Preserve, which is the land that today's detention center sits on. And looking ahead a little bit, I wanted to ask, what do you think Indigenous international law might look like 50 years into the future? What challenges or opportunities are you expecting?
So regarding the future, in terms of what's going to be happening and next steps on this project of Indigenous theories of internations or international law, the logical step is to ask the question about, once we've identified Indigenous legal orders at the international level, then what do we do with them? And how do we integrate them? And I think that's going to be one of the major challenges. We can talk about having autonomous legal systems, and this is that perspective of legal pluralism. But then there's also the discourse about potential integration in some way, or synthesis of some kind, which is a more extreme vision of the international legal order. The challenge, though, is what does it mean to have inclusion, participation, synthesis, these kinds of things? To some degree, we've already seen efforts at this within the existing international legal system. So you have venues for indigenous perspectives in the United Nations, such as the UN Permanent Forum on Indigenous Issues. You have the Human Rights Council. They have the expert mechanism on rights of indigenous people with the UNFCCC. They have their own forum for indigenous voices. The question, though, is, are these symbolic? Are they token forms of representation where indigenous peoples, they're basically put into a room and talk to each other, but then there's no real engagement in terms of voting rights or influence on decision-making? And so I think the question then becomes, does inclusion and participation extend to these kinds of legal rights in terms of voting, membership, impacts on decision-making? Regarding that last point, I think this is a wider discourse that needs to happen. So one of the things that we're hoping to do with this entire project is trying to open a space for discourse where we invite other scholars, indigenous and non-indigenous, to actually come together, to actually start having a discussion about, well, what does it mean to try and provide space and to try to promote engagement with these indigenous perspectives? And what does that actually look like going forward into the future?
So when I work with Indigenous peoples, especially during difficult and uncertain times, I take a lot of solace in their long-term, multi-generational vision of the world and commitment to their values. And international engagement is difficult, it's time-consuming, it requires a very long-term investment of resources. But to me, this actually seems very consonant with Indigenous peoples' approaches to the world. And I firmly hope, but also believe, that despite challenges, Indigenous peoples will continue to insist on a seat at the table, raise their voices, and shape international law in a way that makes this world better for everyone.
Fantastic. Just wanted to give you both an opportunity to maybe share some things that are coming up in your work. And Jonathan, with the book particularly, what can we expect from the other chapters?
We're still in the process of looking for additional authors. We currently have 20 chapters that we've received. So we actually have 20 manuscripts. And thanks to all the authors who've contributed, all from around the world, incidentally, from the various geographic regions of the planet. And it's been really educational to see these different perspectives and different voices. And this is even with the language barrier, because everything's going into English language. And it's been really just an eye-opening experience for those of us who are editing this. Obviously, this is just a very small sample of the larger Indigenous discourse, and we don't claim to be comprehensive. We would be very open to additional chapters. We are going to start the process of internal peer review probably in February, March 2026. And this is more of a way of allowing authors to meet each other and to actually get a chance for authors to come together. And then with the publisher that we're working with, it looks like, according to their timelines, we're looking at the end of 2026. So we're going to try to get additional chapters in before that timeline and hopefully get everything together. And then once we do that, we want to use it as a means of launching this larger discourse and a way of publicizing this particular issue space for scholars, not just in international law, but in different disciplines and also in different parts of the world, and to hopefully foster a wider discussion about the kinds of issues that we've been talking about today. So thank you.
So in terms of forthcoming and available work through the implementation project, we have a number of publications that are geared toward audiences of lawyers and tribal leaders and others who are engaged in practice. And you can Google implementation and Native American Rights Fund, and the website for the implementation project will come up. Some of our recent and forthcoming publications include the Indigenous Peoples Guide to the United Nations, kind of a basics for lawyers and tribal leaders, Indigenous leaders who are new to the space. We have a guide on operationalizing free, prior, and informed consent in the conservation and development space, a new guide in the works on using the declaration in diplomacy involving Native Hawaiian people, and a number of others coming out. In terms of my own work, I've been working on a series of articles about Indigenous diplomacies in international spaces. And perhaps most excitingly, I am the co-author on the new version of Professor Jim Anaya's teaching book on Indigenous peoples in international human rights. And we hope that's going to be coming out in 2026. It's been a while since there's been an update, but our hope and belief is that law professors will be able to adopt that book by this time next fall. And it's also a helpful resource for practitioners as well.
Well, thank you so much for joining me on the podcast today. I really enjoyed learning more about Indigenous theories of international law and how we can better engage with Indigenous communities on the global stage. I think our listeners will take away a lot from this conversation and its implications for environmental law broadly.
Thank you, and thanks for this conversation. It's been really great, and hopefully we'll be able to continue the conversation in the future.
Thanks so much for including me. It was great to talk with all of you, and I look forward to future collaborations.
Thank you for having me as well, Sebastian. And thank you especially to Kristen and Jonathan for all of your insights. It's been really cool as a young Indigenous scholar to get to learn from the both of you. So thank you.
Thanks for tuning in. I'll see you next time.
Thanks for listening to People, Places, Planet, the official podcast of the Environmental Law Institute. Our work wouldn't be possible without the support of people like you. If you'd like to learn more about what we do, attend one of our events, or support our work financially, head to eli.org.